Michael Popok, let's talk about how the absolute immunity decision by the Supreme Court granting Donald Trump absolute presidential immunity, how does that affect the Washington, D.C. federal criminal case, the Mar-a-Lago document case, the federal case in the Southern District of Florida? How does it affect the state case, the racketeering case in Georgia? Does it have any impact on the Manhattan District Attorney case where there's sentencing happening on July 11th? Does it affect any of the other cases, the ones brought against Mark Meadows, the case brought against Jeff Clark and other individuals who are named in these other indictments? How is this going to be impacted? First, let's just go through, remind everybody about what the Supreme Court's analysis was in their absolute immunity bombshell decision, which held that presidents of the United States have king-like powers. In the first instance, the United States Supreme Court said that presidents should be afforded absolute immunity for anything that would be considered core presidential powers. In the next analysis, the Supreme Court says not only that, but anything that could be deemed to be official conduct of a United States president, and there should be a strong presumption given to the fact that basically anything done in office would be constituting an official act. You should also get absolute immunity for that. And then when you're going to this next category of unofficial conduct, whatever that may actually be, this small sliver of conduct that may be deemed to be unofficial conduct, that's not entitled to absolute presidential immunity. However, if any of the conduct that you engaged in would otherwise be afforded absolute presidential immunity, whether it's core presidential power things that you are doing, or whether it's things that could be deemed part of your official conduct, that cannot be used at all as evidence in any criminal trial regarding unofficial conduct that would be criminal. So if you were trying to establish the mental state of Donald Trump, his mens rea, you could not use the pattern and practice, for example, of his communications with former Vice President Pence, because you would argue that's official conduct, communications between president and vice president, or even communications between president and chief of staff, Mark Meadows. You would argue, if you were Trump, and I'm not giving him advice, this was pretty much laid out in the Supreme Court decision, that would be deemed official conduct, that would be excluded from the trial. So let's break it down, Michael Popok. Do you think this is going to impact the DC case, the Mar-a-Lago document case, the Georgia case? Can it even have any impact on the Manhattan District Attorney case? Let me give you at the highest level, this, in my opinion, guts the January 6th case in Washington, D.C. Trump will argue all of that conduct is either core presidential powers or official conduct. And then in any event, when an argument will be made by Jack Smith that I think would be a good one, that, look, this conduct was campaigning. It was unofficial conduct in nature. Think about the Blasingame decision. This was outside the outer perimeter. First and foremost, that's going to take years to appeal now. It'll go back up to the Supreme Court before there's ever even a trial held. But then even if you establish those are unofficial acts, you won't be able to bring in key communications that Trump had with the key players, because that will be subject to official acts immunity, and that can't be evidence in the case. So I think it pretty much guts that case. The Mar-a-Lago document case, Trump taking the boxes, putting things in there, packing. He'll argue they're official acts. He's got a judge in Judge Cannon who will probably see, oh, the Supreme Court's giving me license to be bold. Justice Clarence Thomas, in his concurring decision, gave Judge Eileen Cannon the go-ahead to even find that Jack Smith should not even been appointed in the first place. I think that she'll probably dismiss that case. I think even though it shouldn't gut the case because a lot of his conduct was after he was in office, that will take years to appeal. I think it completely guts that case. I think it guts the Georgia case as well for the same reasons that I give there. And then people aren't thinking about this, but it could impact the Manhattan case, which has sentencing on July 11th, because there was some evidence brought in of how Hope Hicks interacted with Donald Trump, how he got letters at the White House, his process for getting information, when he threw events at the White House, like when he invited Cohen and Pecker over, and that was used to establish mens rea? Could that now be argued that those things should be excluded and that there's going to be issues there with that criminal trial as a result? That's my high level. In 5 minutes, let me hear yours.
Let me start backwards with the New York case because that's on everybody's mind. I'm less concerned that in the three buckets, think of the decision, everybody, like a waterfall. And the waterfall falls into three buckets. They're not all equal sized based on immunity. First bucket is very large, and it will capture all things that are literally listed in the U.S. Constitution that are presidential powers under Article 2. We call them core presidential powers. They're actually expressed in the Constitution. For that, the guy's getting, any person's getting, and Trump in particular, absolute immunity, which is exactly what it sounds like. You can't be prosecuted. And if you got prosecuted, that prosecution gets dismissed. And if you got convicted, those convictions would get vacated. Then you've got in the next bucket, which is not as large as the of core, but pretty large in and of itself. Anything that's officially you're wearing your president as president hat. Okay? That is an immunity that's not absolute, but there is a presumption that it will be immune, and to overcome that presumption is very difficult. And that requires that the trial judge analyze whether it's an improper interference with the execution of the powers of that office. And then in what I like to refer to as a shot glass, which is the size of that bucket, is everything else, which would be unofficial conduct. Unofficial conduct could be, once you say it's not in the absolute core, it's not in the official, it's what's left over, right? It's in the remains. And of the indictments and all of these places you've identified, and I'll start with New York in a minute, there is very few things that fit neatly into the shot glass at the end of that waterfall, allowing for prosecution. And in particular, the Supreme Court, in its majority decision written by Roberts, told the DC election interference judge Chutkan what she has to automatically find is immune. They told her, you know, there's 4 major things you're looking at in the indictment. 3 of them, he has either absolute immunity or immunity for which you will be unlikely, although you can take a look, Chutkan, unlikely to find that there is an ability to overcome the presumption. Jeff Clark, the weaponization of the Department of Justice, is out as a foundation for any part of the indictment. The interactions between Donald Trump and Mike Pence, out as vice president to president, no matter how you characterize it, no matter what the motive, out. Then you're left with the interactions that Donald Trump had with election and elected officials in the various states to try to cling to power. You know, those phone calls to Georgia and the Secretary of State and others, maybe in, maybe out, up to the judge to determine, and only if she determines that it doesn't improperly interfere with the functioning of that executive branch. Very hard burden for the prosecution to overcome. Then you're left with all the stuff on Jan 6th. I mean, literally on Jan 6th, from the ellipse to the attack to the insurrection, the attempt to burn down the people's house and assassinate who's ever inside. And that may or may not, depending upon whether the judge finds it to be unofficial acts, even though it wasn't clear to the Supreme Court. They didn't want to make that decision. They made the decisions about Jeff Clark. They made the decisions about the weaponization of the Department of Justice and about the interaction with Mike Pence. But the rest, we're an appellate court. Let the trial court do that over the next 6 months or a year. Delay. Let's go to New York. New York, the bulk, I mean the lion's share of this iceberg is above the water, having nothing to do with the presidency. It had to do with candidate Trump trying to hide, leading into October and November of the election year, his sex act with a porn star and the payoff related to it. There was some testimony about Hope Hicks about the campaign of Donald Trump and how they reacted to it, and some small behavior and check writing that happened while Donald Trump was in office. Even this decision that just came out, I don't think the judge, he'll have to acknowledge it, Trump will move against it to dismiss. even the judge here will say, even under the new decision in U.S. versus Trump or Trump versus the U.S., this does not constitute immune conduct. It falls into the category of private, unofficial act conduct. And I think New York will be fine. And I think the Court of Appeals ultimately in New York, when this issue is invariably raised by Trump on his appeal, will also find that, because they'll bring it up on their brief. They'll bring it up in the sentencing memo, but they'll bring it up in their brief to the appellate court. DC election interference, Judge Chutkan's got her work cut out for her. She's got to get rid of everything in the indictment about Jeff Clark, Mike Pence, and most of the other allegations, and has to then determine whether the interaction between Donald Trump and private actors and state officials and others constitutes unofficial conduct, yes or no, after she goes through an analysis, meaning briefing, meaning this is going to be through the summer, and we're not going to get this thing up and running before the November election. And if Donald Trump were restored to power, it means that the Department of Justice's cases will be dismissed, and she won't have to do any more work because the prosecutions will be dismissed. Putting aside self-pardon, which is a possibility under this MAGA right wing. So Chutkan gets the case back next week. She calls the parties together. She lays out what she's got to do based on the new ruling and the new razor blade she's been given. And if there's anything left of the indictment, then she will say that's what's left. She also has to apply the new ruling in Fisher about whether 2 of the 4 counts, an obstruction of an official proceeding and the creation of false evidence in the form of certificates, still survives. And so if there's anything left of the case, then you're up on an appeal, first to the DC Circuit Court, appellate court, and then to the Supreme Court. I mean, I think you can pick up from our tone in this hot take, this trial is not happening. Mar-a-Lago is, yes, there's conduct mainly after he left the presidency. A little bit while he was president, and he didn't properly return the documents to the National Archive at the time. That bad behavior continued when he became ex-president. And so now you've got a unstable and unreliable jurist in the form of Aileen Cannon having to apply this decision and having to determine whether anything falls into this remaining unprotected, not immune class of private conduct, unofficial conduct. You know what she's going to do. She'll bend over backwards to try to stick it in the other 2 categories, and therefore have an appeal to the 11th Circuit, and then we're back around to the Supreme Court, and now we're into 2025. And she's been given a gift, even though it didn't end up in the majority opinion. In the concurrence by Clarence Thomas, as you pointed to, he invites and supports the motion to dismiss that Jack Smith is illegitimate, that the special counsel was improperly and invalidly appointed and illegal, and therefore the whole indictment should be dismissed. And now somebody, you know who, Trump's lawyers, are going to point to the concurrence. Again, didn't show up in the majority, but it does give a roadmap and support for the argument, an argument you and I thought was ridiculous. Georgia, I mean, anything related to his official conduct, and she had Fani Willis, as we noted earlier, she was brave. She had a very sweeping, broad, not surgical indictment of Donald Trump and 18 or 19 others. And in it is a lot of what was in Jack Smith's indictment, a lot of what's in the Jan 6 committee report, and a lot of now will have to now be ripped out and dismissed because Judge McAfee, having getting a new motion under this precedent, is going to have to take his razor blade and cut out anything that falls into official conduct, core conduct, and then try to figure out what's unofficial conduct at the very end. There'll be parts of Georgia that are left, but it's going to be up to the prosecutor to decide what she's going to do. Her case just got turned completely upside down and ripped to shreds. And then you've got one last note on that. The other people around Donald Trump, the president enjoys this immunity that's just now been established, whoever's in office, not the minions around him. So you're not going to be able, it's not like executive privilege. I don't believe you're going to be able, as a Jeff Clark, a Mike Roman, well, Pence was a prosecutor, to Mark Meadows or the rest of them, to say, aha, the big guy got immunity. Therefore, no, that's not how absolute immunity application works. But you know they're going to try it. And so this is the new world order and disorder that's been established by this United States Supreme Court with this. I mean, you said it in a prior hot take. We can't even communicate in words as human beings how much of a radical reformation of the relationship between the three co-equal branches of government and the president and the people has just occurred overnight with the issuance of this new order.
As I said in the prior hot take, if conservatism meant conserving the monarchy, the current Supreme Court dutifully and gleefully executed that function and brought back a monarchy here in the United States. I mean, and I'm not, y'all know me. I don't use hyperbole on these shows. I mean, I am citing what the dissenting opinions state. The Justice Sotomayor dissent, the Ketanji Brown Jackson dissent states that what the Supreme Court did is say that the United States president is the king and can order SEAL Team 6 to kill political opponents, can order the military to engage in a murderous massacre of their political opponents and kill everybody in the other political party. And that would be considered a core presidential power utilizing the military, or that would be considered official conduct and they would have absolute immunity. Or as Justice Sotomayor said in her dissent, immune, immune, immune. That's what Donald Trump's lawyer argued for in the oral argument. Donald Trump's lawyer was asked, so you're saying that you can order SEAL Team 6 to do this? Yes. Yes, that's what we're saying. So you're saying that Donald Trump could have fraudulent elector slates? Yes, that's what we're saying. It's out there. It's in the open. This is the choice that we have. We see it. It is there for us all to see. That's why it's unhelpful to intellectualize. It's something that needs no intellectual analysis. It requires, it's a very basic thing that they're saying. And I'm not okay with that. That's not what the Constitution says. That's not what we, the people, want or what we should have. We should not have kings. It's just that simple to me. Anyway, let me know what you think in the comments below. Michael Popok, thanks for this continuing analysis as we explore now the ripple effects of this horrific decision go down as, you know, think about this court overturning Roe v. Wade and Dobbs, overturning Chevron and destroying all administrative agencies' ability to function, holding that presidents are kings and can kill their political opponents. That's what this Supreme Court has given us. Oh, and then bump stocks are legal as well. And if you don't think decisions like that play into some of these other ones, when you have the proliferation of, anyway, they're all related. Think about it. Anyway, hit subscribe.
One last comment, Ben. Hold on, Ben. One last comment. Once again, the Roberts as Chief Justice is circling the drain of history as the worst Chief Justice we have ever had. And its decisions that you've just laid out and the ripping off of America and the super precedent that's been on the books for 40 and 50 years, time and time again, to remake the American democracy in the image of MAGA right will be punished in the future. And I'm sure the one that doesn't look kindly on them by historians and Americans in the future. Unfortunately, you and I and our audience have to live with the ramifications of it today.
And we have to be the solution.
Yeah.
We have to be the answer. That's the way this happens. This doesn't happen if we run away in fear. We have to be the answer. Hit subscribe. Let's get to 3 million together. Thanks for watching.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.